My name is Francisco Rosa. Welcome to another video. In this channel, we talk about all topics real estate. Today's topic is damages. As a real estate attorney and attorney in general, one of the things that I always hear from people is, I want to sue him. I'm gonna file a lawsuit. I'm gonna make a complaint. And sometimes what I'm hearing are simply complaints. That's when you have some criticism or negative feedback about a person. Today's topic is damages. As an attorney, if you ever file a claim, you must have a goal in mind of what it is that you would get if you win. I never deal with criminal matters, but if you understand a criminal case, if the state wins, you might be fined or jailed. In civil litigation, which what we call is private matters or non-criminal, whenever you sue somebody, there is an end goal in mind. For the most part, it's always about money, but you may be entitled to an injunction or specific performance. So let's cover damages. If you have a contract and somebody breaches it and you lost the benefit of that contract, you can try to quantify what your harm is. That is, if the contract had been fulfilled, I would have done X amount. That is, you have to try to justify to the court what your damages would have been. So for example, if we had an agreement that you were going to sell me something, which I then resell for a profit, my damages are the profit that I would have gained if this contract had been fulfilled completely. Some people believe that they might be entitled to consequential damages. Consequential damages are harm or injury that results in the failure of a contract happening. Let's think of an example. You pay $2 to take the bus, but the bus breached their contract to pick you up on time. As a consequence, you must take a taxi that costs $20. Now, are your damages $20? No, because you would have paid $2 anyway, so your damages are only the difference. The bus company does not offer a guarantee that they will be liable for consequential damages in failure to picking you up. So it's your duty to make sure you're there on time. But that fact pattern is a typical occurrence when somebody does not comply with their work. For example, if I have a contractor that's supposed to show up on Monday and finish work that takes 2 days, Monday and Tuesday, and I've hired an additional contractor to come in on Thursday, if the first one fails to show up or doesn't finish the work on time, I will be liable for a deposit or a partial payment to the contractor that can't actually start working on Thursday. Why? Well, because they've taken the time off another job. They're expecting to earn money from me, and in not being able to do their job, although they aren't actually working, they still expect to get paid for their day's work. So you hypothetically have the possibility for consequential damages. I mentioned this as an example, but you gotta remember, most contracts exclude consequential damages. That is, they specifically do not allow that they'd be liable for any unanticipated costs. They may accept responsibility for their wrongdoing, delays, and failures to comply, but not as a consequence of somebody else's harm. Finally, we have what's called breach of contract. Breach of contract is nothing more than you failing to do what you promised. If I was going to pay you $10,000 for a project, you started the job and I spent $5,000. I have $5,000 worth of work left. But what if that work by a new contractor cost me $7,000? I would have spent 10, but I ended up spending 12. So in that scenario, the original contractor that breached the agreement would be liable for breach of contract damages of $2,000. That is, the damages that I've suffered as a consequence of their failure and incompletion. You must be careful about the language in work estimates and contracts used by the people that work for you. For the most part, they try to restrict or limit liability specifically because they don't want to take responsibility for incompliance. One way to tackle this is simply to ensure that your contract states a due date. Many people make the mistake that something that may be simple and should get done fast, simply agree it costs so much, but they fail to account when it will be done. If the contractor has delays, you're still on the hook to pay because you didn't state when they need to do the work. So ensure that if they need 3 days, you put in work to be completed in 1 week. If it's a 15-day project or 30-day project, you put in work to be completed in 60 days. In addition, you do have the power to negotiate. Therefore, you can easily add the penalty for incompliance is $100 a day until the date of completion. Or in the alternative, you can state the parties retain the right to terminate the agreement if the work is not completed by X date. Again, regrettably, these are things you only learn after dealing with difficulties, but it's best to take the advice from people that have dealt with contractors before and follow the standard practice. Deposit at the beginning, progress payment, and then final payment, usually a third or 25% upon completion and satisfactory closure of all permits or inspections of work to be done. One final note, depending on where you live, even if you have to sue somebody for breach of contract to claim damages, most states do not allow you to get attorney's fees. So this is one of the conundrums that most people face. Having to file a lawsuit for somebody for $500, $1,000, or $2,000 when the attorney fee happens to be $500, $1,000, or $2,000. If there's no right to attorney's fees and you are due $2,000, chances are your attorney fee is $2,000. So one other consideration for most contracts is you can add, if there is a breach of contract, the parties are entitled to pursue civil litigation or file a court complaint. And the phrase that you're looking for, the prevailing party shall be entitled to attorney fees and court costs. That will ensure if you are not able to successfully negotiate a resolution privately with the contractor, they understand if they get sued, not only will you win your actual damages, but you will also be entitled to a reimbursement of your attorney fees. Most states do not allow attorney fees unless it's specifically written into the contract. So be careful about that, and good luck, and hopefully you never have to worry about suffering damages as a consequence of contractor breaching their agreements or contracts to do work for you. Thank you for watching, best of luck, and come back to this channel and stay tuned for more videos.